G'day everybody and welcome to topic 4 for Laws 11062 Contracts B. My name's Anthony Marinac and this week we're going to be having a look at the next of our series of the ways in which contracts can be vitiated, or in other words, ways in which contracts can fall over completely. And this week we're going to be looking at unconscionability, duress and undue influence. So this is a bit of a catch-all topic because it's got 3 different subtopics in it, but I'm sure you can see almost immediately that those 3 subtopics do go together quite well. So what are we going to be having a look at this week? Well, we're going to start out with unconscionability, and unconscionability is another one of those equitable concepts that we strike regularly in contract law. We're going to talk about what unconscionability is and what effect it has on contractual obligations, particularly those contractual obligations which are either made unconscionably or which are unconscionable just automatically and in themselves. We're going to look at the protections that equity offers to those who are under a special disability and those who are under an inequality of bargaining power. And we're going to look at what the limits of that are, because obviously in most circumstances people who are making a contract are not doing so on a fully equal and equitable basis. We'll look at duress and what protection the law offers those who are forced to enter into contractual obligations under duress, and at the same time we'll have a look at what the differences are between duress as we look at it in contract law and duress as you will already most likely be familiar with from criminal law. Finally, we'll look at influence and we'll look at the protection which the law offers to those who are unduly and unreasonably influenced by another person at the time that they're making the contract. So we'll start with unconscionability. Now, if you think back to contract A, I seem to be saying that a lot, but the two really do go together. If you think back to the start of contract A and you think about our elements of contract formation. Now, one of those elements of contract formation that we talked about was capacity. And we said that minors, mentally ill people, and under some circumstances people who are intoxicated may not, in fact, be able to enter contracts. However, they also can enter contracts. A minor, for instance, can enter into whatever contracts they like. It's just that the contract won't be enforceable against them. So those laws of capacity enable all sorts of people who may not actually have full contractual capacity to enter into contracts. From that perspective, they're fairly generous. From another perspective, however, they're quite narrow, because there may be people who are not minors and who are not mentally incapacitated and who are not intoxicated by drugs or alcohol, and yet who are still, for one reason or another, under a disability which makes them vulnerable. If somebody takes advantage of that vulnerability, the law says that that is unconscionable. It is contrary to conscience. And the court won't stand for it. Okay, essentially a contract, if we think about our classical theory of contract, a contract is supposed to be an expression of freedom. It's supposed to be a free agreement between two people which the courts will then go and enforce. Now, it can hardly be a free agreement if one of the parties to the contract knows about the vulnerability of another party and is quite deliberately just taking advantage of that. That's not cool. So how do we deal with unconscionability? Well, the best case to look at, and it's a case that you will already be familiar with from last term, it's a case called the Commercial Bank of Australia and Amadio. It was a 1983 case, and it's reported in volume 151 of the Commonwealth Law Reports at page 447. Now, Many of you will remember that in that case, the Amadios had a son who was a businessman, but not a particularly good one, and he convinced his parents to assist him to raise capital for a business venture. His parents had very poor command of English, and they were given documents to sign. They signed them. They didn't understand that what they were doing was essentially putting their home at risk if the son's business venture failed. Now, the bank knew that the only person who had explained these documents to the Amadios was their son. They knew that the son had that the son had every reason to not be telling them the full truth, and so the bank was really under a duty to make sure that the Amadios actually did fully understand what they were doing before they did it. The bank didn't exercise that duty. So you can see there that the Amadios' special disability was their limited command of English and their vulnerability to the influence of their son. Second case that we'll look at is called Blomley and Ryan. Blomley and Ryan was a 1956 case, and it's reported in volume 99 of the Commonwealth Law Reports at page 362. Now, in this case, there was a land deal going on, and it was known that Mr. Ryan was a drunkard, essentially, that he had problematic drinking habits, and that as a result of having had problematic drinking habits for many decades, he was now at the point where his faculties were essentially impaired, but not to the point where he lacked the capacity to contract. Certainly, though, to the point where he was vulnerable to others. Now, the purchaser who was trying to purchase Mr. Ryan's property arranged that at the time of the negotiations he should be given a bottle of rum and encouraged to go on a drinking spree. And he did so. He went on a drinking spree the night before, essentially the night before the big contract was signed. Now, you don't have to be a particular genius to see the lack of conscience here, that you're doing a deal where you're trying to rip off a drunkard, and so the way that you make sure that you get the fullest possible advantage out of it is by encouraging him to get as drunk as possible immediately before the big negotiation. Pretty easy to see why the court wouldn't stand for that. The third example that we'll have a look at is quite a famous case now called Louth and Duress, and look, I really do feel sorry for Mr. Duress, because he's probably still around the profession somewhere, but he's now become a byword for those wounded in love. What happened in Louth and Duress was that Mr. Duress fell head over heels for a lady named Carol Louth, and he had proposed marriage to her. And she declined his proposal, but having declined his proposal and moved away, she moved, in fact, from Launceston to Adelaide. She didn't cut him away completely. She declined his proposal, but they stayed in close contact, and to all accounts, there was some encouragement given to him to continue to harbour his feelings of love towards Ms. Louth. And from time to time, when things got difficult for Ms. Louth, which seemed to happen regularly, her life seemed like a bit of a bad TV drama by all accounts, she would contact him and seek his help, and he would charge in like a knight in shining armour on a white charger and would help her out. And in the end, he helped her out to a very great extent with financial assistance. But then finally, she was about to be thrown out of the home of the relatives that she'd been staying with. And he agreed to purchase a home for her and transfer it into her name. No doubt he was hoping that this would be the final and dramatic gesture of his love, and that the home would eventually become their matrimonial home. But no such luck. He purchased the home, which he couldn't really afford, put it in her name. 2 years later, they had a falling out. And he said, well, at this point, seeing as we've had a falling out, I would like to transfer the home back into my name, and I'd like you to start paying rent, please. She refused. She said, this is my house. It's in my name. Now, we've looked at 3 circumstances. Can you see the unconscionability in all of those 3 circumstances straight up? I mean, just even without legal analysis, you can see that each of those 3 situations is not kosher. It was not okay for the bank to knowingly encourage someone to put their home at risk, even though the bank knows that they don't quite understand that that's what they're doing. That's not okay. It's not okay if you're negotiating a land purchase with somebody who has a drinking problem to send them a bottle of rum and send them out on a drinking spree the night before the deal goes down. It's not okay if you know that somebody has become emotionally devoted to you in an unreasonable way to encourage them to buy a house for you, and then to refuse to allow them to have any of the financial benefit of that house when the relationship sours. These things are not cool. Having looked at them just from the perspective of common sense, though, let's now do the legal analysis. There are 3 steps here in our unconscionability. The first is that there has to be a special disability. Now, the special disability in this sense is not defined in the way that we would define disability, for instance, in the Disability Discrimination Act or anything like that. We're not talking here about a physical or a mental disability. We're talking about a legal disability. So this is something which affects their ability to make rational decisions in their own interests. Being in a wheelchair, as I've said in the slide there, is therefore not a special disability for the purpose of unconscionability, because someone who's in a wheelchair still has every capacity to make rational decisions in their own interests. The fact that they may not be ambulatory does not affect their ability to look out for their own interests at all. On the other hand, our friend Mr. Diprose, who was perfectly capable from both physical and mental perspective, he was under a special disability because of the nature of being head over heels in love in a quite unreasonable way that he was. So when we're looking for a special disability for unconscionability, we're looking for somebody's ability or inability to make rational decisions in their own interests. Second element, the other party must know about the special disability. If the other party doesn't know about the special disability, then they're not really taking advantage of it, are they? So let's look at our 3 situations. Commercial Bank and Amadio is pretty easy to understand. If the bank had never known, if the Amadios had come in and they'd signed the documents and they'd seemed to know what was going on, and there was no signal at all to the bank that the Amadios didn't quite understand what they were doing, well then, under those circumstances, it would be pretty hard to say that the bank was somehow prevented from proceeding with the contract, wasn't it? Because they haven't done anything contrary to conscience. There's no signal there to say to them that there's any need for particular additional care. Blomley and Ryan, if you didn't know that you were dealing with someone who had a persistent drinking problem, well then, under those circumstances, you might not know that they were going out on a drinking spree the night before the negotiation. And even under those circumstances, if you were doing a deal and the deal had been a particularly good one and you were just that right sort of person, well then commemorating the deal with a bottle of wine or a bottle of whiskey or a bottle of rum, it might be a little bit unusual, but it wouldn't be really untoward, would it? So you can see under those 2 circumstances with the bank and with the Blomley and Ryan, if the other party had not known of the special disability, it's pretty hard to say that they were acting unconscionably. Now, With the Louth and Diprose situation, much harder to deal with from that perspective, because it's pretty difficult to see how Ms. Louth could ever have failed to understand just how reliant upon her emotionally Mr. Diprose was becoming. So it's pretty hard to see any alternative other than her knowing about that special disability. So that's our second element. First element is there must be a special disability. Second element is that the other party must know about it. Third element, the other party must take advantage of the special disability. So if you're making a contract with a party who has a special disability, and you know about that special disability, but you are careful not to take any advantage of it, well then, you really haven't done anything unconscionable, have you? As a result, there hasn't been any inequality of bargaining power between the two. If you've acted perfectly ethically towards the other party, even though you know they're under a special disability, there's no reason for the court to interfere. There's no unconscionability there. So how does the court make these decisions? Well, we come to another rebuttable presumption. We've come across these a few times in Contracts A and Contracts B. The court will begin by presuming that the contract is not binding against the person who has the special disability, that the contract cannot be enforced by the person who is allegedly acting unconscionably. But that presumption can be rebutted. So if you are the party who's engaged in such a contract, you can show that the way that you engaged in that contract was not unconscionable. If you can show that, then the court is not going to give them a get out of jail free card. They're not going to simply be able to walk away from the contract because they were under a special disability. So, for unconscionability, we've got our three elements: special disability, knowledge of the special disability, and taking advantage of the special disability. If those three elements are shown, that raises a rebuttable presumption that the contract is voidable. If you're the other party and you want to rebut that presumption, you can do it on the basis of the facts of the individual case by showing that you haven't taken advantage of the other party's special disability. Let's move on now and talk about duress. Now, most of you, I'm assuming, as Contracts B students, have probably studied criminal law, at least criminal law A, along the way by now, and you probably will have come across the concept of duress. Now, duress for the criminal law essentially means that the act which somebody undertook, the criminal conduct which somebody undertook, they should not be held to account for. And the reason they should not be held to account for it is it was not in effect their act, because they were only acting in the way that they were acting as a result of threats against them which overwhelmed their will. Remember that turn of words? It overwhelmed their will. So they were effectively left with no choice but to do what they had done. Now, under those circumstances in the criminal law, the criminal conduct becomes the act not of the person who did the conduct, but instead it becomes the conduct of whoever it was that was imposing the duress. Now that makes sense. The concept of duress in contract law is pretty similar. It's pretty much the same, but the thresholds are slightly different. In contract law, when we're talking about duress, we're talking about inappropriate pressure. Inappropriate pressure that is placed by one party on another party to do one of two things. The first thing is enter the contract. So it might be that you use duress to force somebody to enter into a contract at all. Second way that you might use duress is by forcing the other party to accept terms of the contract which they might not otherwise have accepted. Now, a third possible way that duress could be used is once the contract is underway, if there is a breach and the other party potentially has an action against you, then it would be possible to impose duress upon that party, essentially threatening them with reasons why they should not proceed with that legal action. So what sort of threats do we mean when we talk about duress for the purpose of contract law? Well, there's three types. The first is a threat to the person or to another person, and what we're talking about there is typically a physical threat. So if you threaten to assault somebody or threaten to beat somebody, threaten to shoot somebody, threaten to kill somebody, those are all threats for those are all threats constituting duress for contract law. Now, threats to a person can also be a little bit broader than that. They can be, for instance, threats to reputation. Let's say that you're engaged in contractual negotiations with somebody and you find out that they're having an extramarital affair, and you threaten to expose this extramarital affair to their colleagues and their spouse if they don't enter into the contract with you. Well, that's a threat against the person, isn't it? And that would be enough to constitute duress for the purpose of contract law. The second type of duress is a threat to property. Okay, so you cannot threaten to damage or steal or destroy somebody else's property if they don't enter into a contract with you on your terms. The third is a threat of economic harm. Now, this one's a little bit more complicated, as we'll find out in a few moments' time when we talk about legitimate and illegitimate pressure, because the nature of commercial contracts between companies is that if you do business with one person as opposed to another person, well, the person who doesn't get the business always suffers. So the nature of competition in a commercial environment is that there's always harm being done to other parties' economic interests. So we have to break that into legitimate and illegitimate pressure. But if you simply threaten, for instance, that if the other party doesn't enter into a contract with you, then you are going to start to distribute information which will ruin their creditworthiness. Well, that's a threat of economic harm, and that's going to be enough to vitiate whatever contract you might have with them. Now let's run through how this works, and then we'll have a look at some examples. We have our three types of duress. The questions which the court will ask is, first, was the victim consent actually impaired by the threat? Okay, so for that to be the case, a couple of things have to happen. First is that there has to be the threat. That seems pretty obvious. Second is that the victim party has to actually consider that the threatening party is capable of carrying out their threat. Now, that also seems fairly obvious if you think about it. If you make a threat towards me, let's say you're a puny little weakling and I'm a big, strong, muscly, fighting man, and you threaten to physically assault me, and I laugh in your face, well then, it's hardly going to be duress, is it? Because I don't believe that you're capable of carrying out the threat. So the victim party has to be actually believing that the threatening party is capable of carrying out their threat. The third part of this is that they have to then actually change their behaviour as a result of the threat. So if you're going to offer to sell me your motorcycle for $50 and the motorcycle's worth $2,000, and I've decided, yeah, absolutely, I'm buying me a motorcycle, and then on top of that you come up and start waving a stick at me and say, if you don't buy my motorcycle for $50, I'm going to crack you in the head with this great big stick, well then there is a threat, and I do believe you're capable of carrying out the threat, but the threat is not changing my behaviour at all, because before the threat I was going to buy the motorcycle. After the threat, I'm going to buy the motorcycle. So the threat itself has not constituted duress because it hasn't actually caused me to change my behaviour. I haven't actually had my consent impaired by the threat. So that's the first question the court looks at, split into those three sub-questions. The second question looks at whether the pressure was legitimate or illegitimate. Now, most of the time, threats to the person and threats to property are almost automatically going to be illegitimate. I don't know of any legitimate way that you can say to somebody, enter into a contract or I'm going to smack you in the face. However, the third type of threat, threats to economic harm, that can be legitimate or illegitimate. In particular, a threat not to enter into contracts or a threat to sever commercial relations is quite likely to be legitimate. So, let's say I go to the hairdressers and I get a particularly bad haircut. And I go back and I go to say to my hairdresser, look, you really did a terrible job and I need someone to fix it up. And she says, well, okay, I'll fix it up, but you're going to have to pay me for another appointment. And I'm not happy with that. And I say to her, if you make me pay for another appointment, I am never coming back here again. Now, that's not an illegitimate threat. It's certainly a threat. And it's a threat of economic harm because it means that she will miss out on whatever income I might have provided to her business. So I'm threatening economic harm. But it's not an improper threat. Because the threat simply to not engage in contractual activity with another party is just part of commercial reality. It's not an improper threat. Having said that, there are some circumstances under which it could be an improper threat. In particular, where you've got a monopoly or a monopsony situation. For those of you who don't know what a monopsony is where you've got one seller, essentially. A monopsony is where you have one buyer. Now, in those circumstances where one of the parties has massive economic power over the other, then it may be that the threat to cut them off financially and essentially send their business to the wall may be illegitimate. So these things are decided on the facts by the court. Let's have a look at a couple of examples, shall we? First example, have a look, if you like, at the case of Barton and Armstrong. This is a 1973 case reported in the New South Wales law reports of that year at page 598, where there was a threat of murder if a contract wasn't entered into. Now that's pretty clearly duress. I don't think anyone needs that explained to them in short words. A more interesting one, however, is Hawker Pacific and Helicopter Charter. Now, this is a 1991 case, also from New South Wales, reported in volume 22 of the New South Wales Law Reports at page 298. Now, Hawker, for those of you who don't know much about aviation, Hawker aircraft are really significant helicopter company in the aviation world. And they had sold helicopters to the Helicopter Charter company, and the Helicopter Charter were having those helicopters serviced by Hawker Pacific. And Hawker Pacific then, essentially having gotten hold of the helicopters because they had been sent to Hawkers for the work, essentially said, look, if you want to see your helicopters all over again, then you're going to have to pay the price that we demand. We're going to essentially hold your helicopters hostage. Now, you can see there's a threat of economic harm. Okay, because if we've got your helicopters, you can't be deriving an income from those helicopters because you can't be chartering them out to people. And you can also pretty clearly see that that was an illegitimate threat of economic harm. It's not okay to exercise a power of control over someone else's property like that. Now, under those circumstances, obviously, for those of you who've studied torts, you would know that the owners of the helicopters would have had an excellent case in detenue, or indeed they would have had an excellent case to just encroach upon Hawker Pacific's yards and fly the helicopters away. But setting aside that question, if we look at the question of whether the contract between the two was valid. In this case, it was not. They would not have been required to pay the price that was being demanded by Hawker Helicopters because the contract between them was vitiated by duress. So we can see there all of our elements. Was there a threat? Absolutely there was a threat. Pay us more money or you're not getting your choppers. Were they capable of carrying out the threat? Well, yes, they were. They had the helicopters in their facilities. Was the behaviour of helicopter charters changed? Well, yes, because they had to agree to the higher price in order to get their helicopters back. Was the nature of the threat improper? Absolutely, the nature of the threat was improper. You can see that we've ticked all of those boxes. We've got a case of duress. Okay, we've moved ahead of the slides a little bit there. That doesn't often happen to me, but you can see, we'll race through them again so that there's audio for each of the slides. You can see that the slide that I've just drawn up now goes through those elements of the impairment of consent. So there has to be a threat, have to consider it capable of carrying the threat out, and it must be one of the reasons for the victim's behaviour. One of the things at the bottom there is that it doesn't have to be the only reason for the victim's behaviour. It just has to be one of the reasons for the victim's behaviour. So it's not enough to show that there were other reasons why the victim might have behaved in that way. If the threat is even one of the reasons why the victim has signed up to the contract, then that's going to be enough to vitiate the contract. Illegitimate pressure, some amount of pressure is okay. Unlawful threats are automatically illegitimate. So if what you're threatening to do would break the law, then you're automatically engaged in an illegitimate threat for the purpose of duress. Everything else, question of fact before the court. So that's duress. We're going to move on now to undue influence, which is the third of our nasty trio that we're looking at this week. And undue influence falls into two types. The first is actual undue influence. Now, actual undue influence is actually pretty hard to spot in the cases. It doesn't seem to come up that very often. The main case where we see it is a case called Khan and Khan, which leads to that rather ridiculous picture that I've put on the PowerPoint slide. Those of you who enjoy the Star Trek movies will recognise that as being a character called Khan, but who has absolutely nothing, I must say, to do with the case of Khan and Khan. Actual undue influence occurs where the evidence shows that the relationship between a party means that one party has a significant level of domination within that relationship, and that they're able to use that influence to manipulate the other party into signing a contract which they would not have entered into but for that influence. Now, the case of Khan and Khan is the best example that I can see in our case law of that situation. It's a relatively recent case. It's a 2004 case. Was reported in volume 62 of the New South Wales Law Reports at page 239. And we're talking here about a house sale. The vendor of the house had agreed to a house sale, but it hadn't been completed, and there was still room for the vendor to back away from it. And she was tending to want to do so because the terms of the contract were perhaps a little too generous to the buyer. But she then came under a lot of pressure. Her family members tried to convince her to go through with the sale. Now, that in itself is not undue influence, because people in families influence one another all the time and discuss things all the time and give one another advice all the time, and that's okay. It's going to be very difficult to say that that's an undue influence, isn't it? Because that's really just families being families. However, the Khans stepped over the line when they brought in the imam from their local mosque. And the imam came to the vendor and convinced her, using his very significant authority as a religious leader, to say, I'm telling you that it would be right for you to go through this sale, that you must go through with this sale, that essentially almost saying that God or Allah wants you to go through with this sale. Now you can see that a line has been crossed there. You can see that the influence which is being used on this person now is no longer legitimate. It's no longer just family members providing advice which they think is the correct advice. This is now an imam saying, God wants you to do this. That's a powerful message, particularly to somebody who is a devoted religious follower. That's undue influence. Okay? The relationship between the parties there has resulted in her making decisions, not because she was genuinely a free agent. If we think about our classical contract theory, she was no longer a free agent. She was no longer able to freely agree to enter into private law between her and another party. She'd been manipulated into that situation because she'd essentially been told, agree to the contract which you now consider to be unfavourable, or else you're going to make God angry. Okay, that's not fair. So that's actual undue influence. More complicated, though, is what we call presumed undue influence. Now, presumed undue influence occurs where there is a set of relationships which result in the presumption that the stronger party in the relationship has an undue ability to exercise influence over the weaker party in the relationship. And there are certain relationships that are recognised as providing undue influence, and I've listed some of them there on the slide: parent and child, guardian and ward, doctor and patient, solicitor and client, religious advisor and believer, trustee and beneficiary. Now, once upon a time, an additional one there would have been husbands and wives, with the assumption that husbands were the stronger party and wives were the weaker party, but that's fallen away now. There's really no basis in modern society for that presumption. There's certainly areas of feminist theory which would say otherwise, which say that there is still the strength of a paternalistic system within our society. However, as a general rule, the law of contract no longer presumes that husbands exercise that level of domination over their wives. What you have to understand, though, with presumed undue influence is that it's not just limited to those recognised relationships. There may be any circumstances where the relationship is such that the weaker party places confidence and trust in the stronger party and relies upon them for guidance. So if you're making a contract with someone who relies upon you for guidance, who places confidence and trust in you, then you are under a special obligation to ensure that you don't take advantage of that. What happens then? What happens if there is a relationship and the weaker party seeks to avoid their obligations under the contract? Well, the presumption will be that the contract is vitiated. The presumption will be that the weaker party may make the contract void at their election. The stronger party is then going to have to rebut that presumption. The stronger party is going to have to then show that in fact they did not take advantage of the nature of the relationship. In essence, that's going to mean that what they have to do is show that the contract was fair. Because it's going to be a very difficult task, isn't it, to approach the court and say, well, yes, the contract is unfair, but the contract's not unfair because of the trust that they reposed in me. The contract's unfair for some other reason. That seems a bit silly. In most circumstances, well, in fact, in all the circumstances I can imagine, the only way for the stronger party to enforce a contract under those circumstances would be to show that the contract itself was inherently either fair or favourable to the weaker party. An example to have a look at is Hartigan and the International Society for Krishna Consciousness Incorporated. This is a 2002 case, and its medium neutral citation is as case number 810 of the New South Wales Supreme Court of that year. Now, the plaintiff gave her house and farm to the Krishna Consciousness Society, and she did this because she was of the understanding that this is what was required of her as a relatively new devotee of the Krishna movement, that she understood that what was required was that she should divest herself of her worldly possessions. Now, the first thing is that it was later discovered that the Krishna teachings did not actually require her to do that at all. But the second thing is that this was not really a decision that she could just make for herself, because she had 3 children and she had obligations to those 3 children. And so much as she may be able to choose a life of poverty for herself, it was not reasonable for her to be giving up her house when she had no reasonable alternative means of support or accommodation. Now, the relationship between the leaders of the Krishna movement and the plaintiff were such that the presumption of undue influence arose. Okay, so the presumption was there because as her religious leaders, there was the sort of relationship which would give rise to the presumption of undue influence. As a result, the presumption that the contract was invalid, or that the contract was voidable by the plaintiff, had to be rebutted by the Krishna movement, and they were unable to do so. It's pretty easy to see why. It's pretty easy to see how it's going to be very difficult for you to show that somehow it was reasonable to accept the gift of the house and farm from someone who had no alternative means of accommodation and who was making the exchange on the basis of a pretty thorough misunderstanding of the beliefs of the movement anyway. And so that contract was void. So that brings us to the end of the material for this week. What have we looked at? We've looked at unconscionable dealing and the concept of a special disability. If you can remember Louth and Diprose, and remember that for contract law purposes, being head over heels in love does make you under a special disability, then you'll remember that one forever. Second, we learned that the law protects those who are forced into contracts under duress, which means illegitimate threats to the person, to their property, or to their economic interests. And the third thing we've learned is that the court protects those who are under either the actual or the presumed undue influence of another party. In any of those 3 circumstances, the court will make the contract voidable at the behest of the weaker party, and the court will impose a rebuttable assumption that the stronger party is unable to enforce their interests. Now, that presumption is rebuttable, but generally speaking, the only way you're going to be able to rebut it is by showing that the contract was fair, and that's going to be a tough ask to do. Now, next week we're going to conclude our 5-week examination of vitiation, and we're going to be looking at illegal contracts, which will bring this part of our study to a close. I'll look forward to seeing you then, and in the meanwhile, I'll see you around on Moodle.